Hey there, Ginny Field here, and I am excited to have another episode of Saul Klein and Ginny Field having a conversation about what's going on in the industry. And this conversation takes us through the history of compensation in the MLS industry. It takes us into issues of sub-agency and it going away. It takes us to the issues of how you're paid. It talks about agency relationships, talks about IDX and VOW, and just kind of talks about what's changing. And we must talk about some of that because we have two privately owned MLSs in the country, Northwest MLS and MLS PIN. Northwest MLS is in Washington State, as I recall, and MLS PIN is Massachusetts and covers a lot of the New England states. But that's a realtor-owned entity. Both of these are realtor-owned entities. And they've made some decisions and changes, and you need to know about them. So that's what Saul and I are talking about. We're going to give you, as we always do, a little bit of history and lead into where things are. And I hope you enjoy it because I always love talking to Saul. But most importantly, we are both trying to be of service to the rest of our industry as best our ability to be in sharing what needs to be paid attention to. So I hope you enjoy, and I'll catch up with you at the end. Well, hi, everybody. I am excited because once again, I get an opportunity to hang out with one of my favorite humans on the planet, Mr. Saul Klein. We've known each other for a very, very, very long time. He is an absolute innovator. He is absolutely a visionary. And I'm grateful I get to call him friend because we get to talk about some stuff. And so we're going to have an interesting conversation today about some changes in MLS. But I want to kind of start it by talking about, and I've shared this with you before, Saul, I have been pretty much every class I teach, I break out a tiny bit and talk about the whole issue of changes in MLS and offers of compensation and the absolute vital importance to get a buyer broker agreement, start getting buyer representation agreements in writing. And I've been talking about that now for, I want to say since 2020. I started to see so much going on, and I, you and I are very much the same. We read everything, we pay attention to everything. And so I saw that and I said, I feel an obligation to start talking about it. So as we move forward, fast forward now from 2020 to 2023, we are in a situation where there's a lot going on in terms of MLSs, but we also have to talk about, because I was just talking to a coaching client of mine yesterday who's building a new website. He's opening his own brokerage. And I said, I need you to go out and look at what other MLS agents' websites look like. And I said, because you got to deal with IDX and VOW. He said, what is that? So I clearly had to answer it quick because he didn't have a clue. Because if you're going to build a website, what do you want it to do for you? The hub and spokes method, etc. But he really didn't know about IDX and VOW. And you and I were just talking about, I remember when there was so much conversation about IDX and VOW, and we were all in this large meeting, and all of the dais was filled with everybody of importance, if you will, in that whole conversation. And I joke about this, but it felt like that to me because I grew up in New York, of course. So when I hear the door behind me open, and in walks this whole group of very senior executives from pretty much every brand. And I said, oh, the mafia got here. It was pretty funny, at least to the people around me. So I want to talk about, let's start there, because that whole conversation piece will lead us to what we have to talk about with some changes in MLSs. So, you've got that information. You know more than pretty much anybody, certainly more even than I do. So kind of talk about that, the evolution, if you will.
Yeah. So it's great to be with you. It's always great to be with you. It's always fun to talk to people who've got a history and understand, and where you can actually, years ago I had to work in Anthony Schools teaching real estate in San Diego. And one of the things I liked about it is that once a month, the instructors would get together and debate the questions.
Oh,
right? So that was
favorite.
always great fun for me, right? Sit down and we could talk. And so, because you really get to understand, it's always enjoy our conversations. We can talk about this. And really, we are going to talk about it. Maybe we put it in another segment. We're going to talk about this MLS PIN settlement, but there's so much more to talk about. So let's begin. Because when we talked about that, we got in this conversation about Northwest MLS. We then started to have a conversation about IDX, VOW. So a little history is probably in order here. So let's talk about listings as a marketing asset.
Uh-huh.
So a listing, realtors always have known that a listing is a market. I get a listing, I can run an ad in the newspaper.
Right,
The other
right.
brokers can't run ads on my listings. I can run ads on my listings. I put a sign on the property. The other brokers and agents can't put signs on the property. Only I can put a sign on the property, right?
I have to jump in here because you said something that just made something pop into my head. Remember, I've been in the industry since 1986, and I worked for a small independent company in Fairfield when I first started. And back in those days, newspapers were very powerful and very important, and we had floor time. Remember that? I was good at floor time, but I can remember that often an agent would take a list, and this isn't a good idea. Anybody watching, I don't recommend it, but would take an overpriced listing and advertise it all the time because it was going to do what? It was going to bring buyers.
Make the phone ring.
That's right. That's absolutely right. So go back. Sorry for the interjection, but it kind of mattered.
No, it was. I'm going to give you another story. When I first went to work selling real estate in San Diego in 1975, had a sales license, went to work at a brand new franchise, Century 21, brand new, the whole concept of franchise. Worked for a broker out in Point Loma.
Oh, wow.
The broker didn't provide any training.
Nothing.
50-50 commission split.
I barely had a desk and a phone.
Yeah, 50-50 commission split after the franchise fee. All you got was a desk and a phone. There were only a couple old-time brokers in the office, and I got a call one day on an advertisement, and I took the call, and it turns out, and I asked the listing agent, "What? I didn't know we had this listing." It was right because he says, "Well, it's not a listing; it's my house."
Oh,
Every weekend I run an ad on my house, makes the phone ring, and then I say, "Well, that's not available." So no, not a good idea. But what the fact is that a listing, yeah, he actually did this, right? Because I get a call. They asked me about this property. I'm looking at my
everybody
listing
watching,
book.
don't do that.
It's not in the listing book. I'm saying I don't see a listing in here. Oh, it's not a listing. It's just my own property. Right. So a lot of things happened many years ago. So, but here's the point: a listing's marketing asset. It can make the phone ring, and there are the laws of real estate and the regulations of real estate commissioners forbid you to advertise a broker's listing without that broker's permission. Now, this came way before there was an internet, way before there was a World Wide Web. The rule is you can look it up in every state, and you're not allowed to advertise a broker's listing without the listing broker's permission. Right. And rarely would a broker allow that, right?
That's
because
correct,
it's a listing asset. So then the internet comes along and the web comes along, and I was involved in technology at the time, and my company was building websites. I'd gotten into real estate technology, and I got a call from Brian Larson, who ran, I think it was the Minneapolis Association MLS, and he had a broker who wanted to take the MLS listings and put them on the website. Now, to us, that sounded like taking and advertising a broker's listing without the broker's permission. And at the same time, up in the Northwest MLS, they had the same kind of thing. So this idea said, why don't we create a form of blanket permission so we satisfy the law, which says you can't advertise a broker's listing without the listing broker's permission. So something called broker reciprocity was born. Right. My company, we built the first website. We built it for Brian. We sold it to that broker who wanted it, and nobody else bought anything. That was the only one we sold it. It was kind of an early market. It's like a good friend of mine says, a good idea 10 years ahead of its time is a bad idea.
That's correct.
And so that was broker reciprocity. It evolved into IDX, rules around advertising another broker's listing, complied with the law, and made the technology comply with the law, and we had IDX. And then what happened was there was a real estate company down in Austin, Texas, that wanted to put all the MLS listings with IDX, you had the right to opt out.
Yes, right?
Because we got a broker's permission. And so we created two models. One where you just say, okay, blanket permission granted. If you don't like it, take it back. Opt out of it, or hey, we're going to do it. Everybody, if you want to let your other brokers list opt in. Those markets failed initially with IDX because nobody knew about it, so nobody opted in.
Right.
The successful IDX markets are where people started with all the listings, and if people wanted to opt out, they opted out, but they saw the benefits, so they didn't opt out, so they were successful. So there was this kind of like it's called e-realty. And e-realty, kind of a discount. They were doing things different. The brokers in Austin didn't like it. So they didn't want their listings on e-realty site. E-realty says, you know what? When somebody walks into my bricks and mortar, you're discriminating against a technology website office. See, when somebody walks into your bricks and mortar office, you give them the book to look at, right? You give them these hot sheets to look at.
And do you remember when the code added something about that specific discrimination against types of business models?
Of course.
Remember that the code had to be changed specifically to address different business models.
And that's kind of where, so this, it was an antitrust lawsuit where brokers in Austin and were right. And they said the idea was you could opt out of IDX, but you can't, if I'm actually using a website to conduct business, you're discriminating against my business practice. And so the eRealty won.
Yeah.
And so what was born was the virtual office website.
Right.
And the virtual office website was not about really advertising listing. It was about conducting business, of which a piece of a broker's business is to show the listings. And we had, when someone came in the office, we would have, like I mentioned, we would have different things to show. And so the decision was, whatever you do in a real office, in a bricks and mortar office, you can do it in an online office.
Absolutely.
We need to create rules around it.
Right.
And then what was born was the VOW.
Correct.
The virtual office website. And then in 2008, the National Association of Realtors was sued by the Department of Justice around the VOW rules. And we could talk forever about that, but the VOW was created. And so what VOW is a set of a set of rules that allows brokers, and you can't opt out of VOW.
Right.
You can't, because you might as well, this was the thinking, if you're going to opt out of VOW, you can't participate in the MLS. Because the purpose of the MLS is to let other brokers transact. And so you can't opt out of the VOW, but you can opt out of IDX because that's advertising. So the big distinction in IDX and VOW is IDX is advertising, VOW is conducting business. It's the transaction and everything around it. And so no opt out of VOW. You can opt out of IDX. Okay, so that's kind of the history of that. Now, to kind of throw in the mix, just to, if you're with us so far, right?
Well, let me jump in. Remember, because and I know you're going to go here. I remember when that was first launching, and everybody was saying to all the agents, because remember I was managing in those days. All the agents were saying, "Oh, this is going to be great because your listing is going to be around the whole wide world on the World Wide Web within seconds after blah 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 blah." And then from that were birthed the aggregators, and now people are saying we gave away our data, but in the days that we gave the data, we were looking at it as a benefit to the consumer and to us. And now we're sitting, it's like, okay, it's at some level, go with the flow. It isn't changing. I mean, am I wrong?
So you bring another piece in, that's syndication. So what we basically then had was, and I was instrumental in creating real estate syndication, which was, I coined this phrase for the real estate industry, distribution trumps destination. That's the way I sold the whole concept of, you got to put your listings everywhere because to benefit the consumer. And the idea was, unless you're really good at this as a realtor, how are you going to choose the best sites to put your listing?
Right.
The answer is you can't.
You can't.
So rather than do that, just put it everywhere, particularly if it doesn't cost anything. And that was the way we sold this idea of putting and Walt and my idea behind that is eventually people will realize there's value in this information and we'll be able to monetize around it. That's a whole nother story.
That's a different, we've got a lot. We're going to have a whole series. So
yeah, because all these pieces, right? So IDX was born out of broker reciprocity. VOW was born out of the eRealty case in Austin.
Right.
That was further expanded with formalized rules around VOW through the 2008 settlement. It really was a decision between the Department of Justice and NAR. It was 10 years where basically the rules for VOW, and anybody that wanted a VOW could have one. You couldn't opt out of it. But because IDX was already there, and brokers didn't really make the distinction. And because one of the VOW rules was to do business with someone, you have to make them a client. How do you make them a client? And the way the decision was, well, on the web, the way you do that is they have to register.
Right.
They have to give and the registration was made very basic. All you got to do is give your email. It has to be a functioning email address.
Mm-hmm.
Well, that's very simple. I can go to Yahoo and make up a new email address every day.
Right.
And so that doesn't really mean that person's a client. Nonetheless, that was the criteria for establishing a relationship.
Right.
So
right.
someone could enter your vow. Nobody
Right.
had to do that to enter and look at listings under IDX. So nobody got vows because they thought consumers aren't going to give me their email address. I'm just going to do IDX, right? But they're two separate license agreements, two separate ways to get at listings on the internet. And there was a 10-year period there. In 2018, that was the end of that settlement. And then the DOJ jumped back in and sued NAR again. That's taking us another level.
That's a total different. Let's not go that way just
yeah.
now.
So now we have. Well, let's go. Another important piece here is that the MLS was once a unilateral offer of sub-agency.
Correct. Unilateral offer of sub-agency.
Everybody worked for
those
the seller.
days because when you're managing.
Yeah. Everybody worked for the seller.
Correct. When you're managing at that, and I was managing in Connecticut when that transition happened, and I talk about this as well because at some level, we were all sub-agents. But nobody knew that. Nobody talked about what sub-agency was. Nobody knew that I broke that law pretty much every time I showed a buyer because I'm pointing out the cracks in the crown molding or cracks in the flooring, or did you see the leak, or did you see the rust stain, or whatever the case may be. All while in a sub-agency situation, working for the seller through the listing agent. And when that happened, I forgot, I think I was a cold banker when it happened. I don't remember. But when it happened, it was fascinating because all of a sudden the sellers were getting all ticked off. Well, I'm not paying them. They don't work for me. And my response, being me, was always, did you know they did before?
Yeah.
They didn't know. But there were offers of compensation for $1, $50. Because the requirement was something. So
when you and I first started selling real estate, the MLS, the compensation model was built around sub-agency. How do you get competitors to come together and share the compensation? Now we know that compensation doesn't indicate agency. Nonetheless, the model of MLS, the vehicle that allowed for people to share their listings and share and compensate, that model was sub-agency.
Mm-hmm.
That's what it was built on. Yep. So I got my real estate license in 1975, right up until the 80s. That was the model. It was an offer. But you're right. Agents didn't know it. A lot of brokers did. Here's what we did know. We all knew that we represented the seller. We weren't sure why. I mean, you and I were.
Right. You're absolutely true.
But we knew. When you did, matter of fact, you would even say, don't call the buyer a client, call them a customer. Right? Call the seller a client, the buyer. Say, well, okay, why? Because everybody represented the seller. And the way it worked was the broker got the listing, the broker represented the seller, and all the other members of the MLS became sub-agents of the listing broker.
Correct.
So the compensation could flow.
And it was a hot mess because one of the horror stories is one, it's a bad story when you still talk about it. How many years later, there was an agent that got sued and lost because this was during a sub-agency situation. And she was asked by the buyer, is this the school my kid's going to go to if I buy this house? And the agent said, yes. She was wrong.
Yeah.
Guess who got sued? The seller got sued.
Yeah.
And then it trickled right on down, move on down the road. But the seller was sued. And here's this agent driving a buyer all over the place. You remember the big lawsuit that happened in Minnesota. We're not going to talk about that. But it was clearly a situation where we didn't give training on any of that. Nobody understood what any of that meant. Then, because of who I am, started training on all of that to my agents. So if nothing else, my agents were going to know.
So we all represented the seller.
Correct.
Right? It was a unilateral, and why? Because that was the compensation structure.
Correct.
The MLS was structured that way to allow a flow of compensation where the only person that had a contract to get paid was the listing agent.
Right.
And so you had to have a structure that allowed the compensation to flow. We all represent. Now, we did have some lawsuits that created problems. One was a big one against Forrest Olson, which turned into Goldwell Banker, Forrest E. Olson. And that was because there's something called ostensible agency. Right. An ostensible agency is where someone starts to believe you're their agent. And if
you're a duck, if you act like a duck, if you sound like a duck, you're still a duck,
right? So somebody was sued because they got the buyer believed they were being represented. So what happened then, there was this big movement in the country to big movement towards buyers being represented. Not
Right.
necessarily, but big Consumer Federation of America was behind this. And so what happened in California, and this is the first place it happened, is in California, we instituted, it took, 6, 7 years, we got agency disclosure laws.
Hmm.
And there were 3 proposals to the state legislature. One wanted to make dual agency a criminal offense.
Oh yeah. Oh yeah.
CAR got involved, they negotiated, and what the negotiation was we need to disclose to people the representation. It's
Correct.
not
What is
fair to
right?
buyers.
Right.
And so we don't need to tell them you can't do that, you can't be a dual agent, you can't. All we got to do is let's just disclose, and then buyers will make the decision that's in their best interest. Well, the
Correct.
fact is agents didn't know how to disclose.
No.
There was like a 15 or 18-month period.
Oh
This
my
guy's
gosh.
like 1986 or something. It wasn't, you had 18 months to learn how to do it. 1988, then we had agency disclosure. And in California, you could disclose 3 things. You could represent the buyer exclusively, the seller exclusively, or you
Or
could
both.
represent the buyer and the seller as a dual agent. Well, here's what was happening. Agents now, which were starting to make their disclosures because we had new disclosure laws and new disclosure, but they were making their disclosures, but the MLS was a unilateral offer of subagency. It hadn't changed in 1988. It was still a unilateral offer of subagency. Now we had realtors documenting that they were committing divided agency because they were signing a document that said they represented the buyer exclusively, but they were a member of an MLS where they represented the seller. That was divided agency. One of the remedies in divided agency is you can disgorge the commissions. And this put all of the realtors, the agency disclosure law in California, and then it spread across the country, put all the agents and brokers in great peril of divided agency. So CAR created, so we got to change this subagency thing. How do we change this flow of compensation so that we don't breach our duties and so that we don't have divided agency? And the answer that was created by CAR was change the MLS and change it from a unilateral offer of subagency to an offer of compensation. And so in the early 1990s, and NAR didn't want to go along with it. NAR did not want to abandon the subagency model. And now I'm thinking they were probably, it's probably a lot to that. And they wanted to stick with it, but CAR saw the jeopardy to our agents and brokers in California. So they created something called the CAR model. So you had NAR model rules and CAR model rules. And the CAR model rules were no longer, it was subagency optional, and it was an offer of compensation. And then NAR adopted it. And the rules of the MLS then became
offer of
compensation. Right. So know that the offer of compensation came about, 30 years ago, but it was in response to new legislation. It was an industry response to new legislation, again, to allow the commission to flow. And what these things facilitated, and facilitated might not be the right word. What's it when you help somebody continue in a bad habit? Right? There's a word for that, right? Enablers, right? It enabled only one contract for compensation having to be signed, and that was with the seller. So there never was this, because nobody wanted to get the buyer to sign a contract. Nobody believed the buyer would sign a contract. Everybody thought the buyer would say, nobody else is going to ask me to sign a contract.
Right. And you know what? I have to jump in here because it still all comes down to education and lack thereof. And I still hear that when I'm teaching wherever I am in the country, where it's like, well, I don't want to get a buyer. Well, why not? Because I don't know how to tell them. I said, well, let's talk about that. So I dialogue. I create dialogue. I have conversation. I'm actually going to do something like that for one of my personal short videos. But if nobody knew, because nobody was talking, just like we didn't talk about what subagency was and that it existed, we as an entity, an industry, didn't do a great job of teaching the people that are out there with the consumer on how to have this conversation and why it benefits. Now, there were a couple of companies that I was aware of that decided to create buyer representation companies only, where they did not work with sellers. All they did was work with buyers.
EBAs, exclusive buyer's agents.
Correct. We talked about that in the past. And so, but let's go back to the MLSs. So we understand what happened. We now have an offer of compensation. And we know that some MLSs are Realtor Association owned, and some MLSs are owned by realtors.
So the rules we just talked about,
right?
CAR model, NAR model, now NAR model, not an offer of sub-agency, but an offer of compensation,
right?
Not made to swindle anybody out of anything,
right?
But to allow for commerce to take place in the real estate industry and to be the envy of the world, our multiple listing service,
right?
An offer of compensation. It's been very successful. We could talk about EBAs, and I created something called the California Association of Buyers Agents back in 1992, right? So so now we have offer compensation. Then what happened here a couple years ago is there was a lawsuit, a civil lawsuit, and then another civil lawsuit, Moeller, and then Sitzer, and two major lawsuits that were saying that this offer of compensation is a violation of the antitrust laws. And that what happens is sellers are forced into paying commissions that they shouldn't have to pay because nobody really explained to them they didn't have to pay any compensation. But the MLS required that, even though it could be $1, we kind of got down to that. The fact was there was this argument that if you only offer $1, no other agent's going to show your listing. So you got it to be competitive, offer what everybody, and that was kind of in a way price fixing. And so there's still going on these two lawsuits. They've been certified for class action. Moeller's the big one. Sitzer, this is billions of dollars. And those are the ones we've talked about in the past. But to bring us up to today and what we were going to talk about now is
we're getting there. We're getting close, Saul.
You were there. I think we're there. There's this big MLS on the East Coast called MLS PIN. MLS PIN, Multiple Listing Service Property Information Network. As a matter of fact, I facilitated the first strategic plan for MLS PIN. I think the year was, I was looking at the documents the other day, in 1999. I still have all my notes when I facilitated the coming together of these MLSs to create this broker-owned MLS. Now, here's a big distinction, and you can explain it. There's a difference between a broker-owned MLS and an MLS that is part of this umbrella protected by the E&O of the National Association of Realtors, right?
Right. And that was something that a lot of people don't even know that. They all assume that MLSs are affiliated with NAR, which is not the case. But what and there are two big ones. And in the case of, in both of these cases, from what I've read, and there's the fundamental difference is that a broker-owned MLS doesn't have to pay attention to the same rules as an association MLS. That's a simplification of that. But here's the thing that's interesting. The broker-owned MLSs didn't have to follow any of those rules, but chose to and stayed with the blanket rules of MLS that came. Am I correct in that?
Pretty much. There might be some differences, but yeah.
And so now we're in a situation where MLS PIN, this is recent, and then Northwest MLS, which happened last year, as I recall, toward the end of last year, have decided that they're going to change commission structure, and we have to talk about that. I mean, go ahead.
And it's not so much change of commission structure. It is that, remember that the glue that holds the MLS together is that you can flow commissions.
Right.
And the model of flowing commission was sub-agency, and the model of flowing commission changed to offer compensation, and it worked, so nobody changed it.
Correct.
Right. And there even was this thing where we never would advertise the commission to the selling office. Remember that? So we actually used to indicate the commission the listing office got, and but we took that out because by showing that, it kind of showed, hey, there's, people can always conform, and that can be price fixing. So we never would display this. And so that what became the habit was nobody explained to a seller with any great passion that the seller didn't have to provide or pay the same amount of commission that all the other people are paying. And so there were these cases that came about, Sitzer and Moeller, and then MLS PIN.
Right.
And so the other day we read and when in the MLS PIN case, also the major franchises were named. Keller
Right.
Williams,
Right.
Anywhere, all of the major franchises were named. And here was a surprise. MLS PIN agreed to a settlement, agreed to pay the plaintiffs $3 million to get out of this class action lawsuit, where damages have been estimated into the $1 billion range.
Billions of dollars, yes.
Right. And so $3 million on a $1 billion case, pretty good deal. So they settled for $3 million. And part of the settlement was that the MLS then had to incorporate somehow a way for agents to indicate to sellers that they don't have to pay a commission to the buyer's agent. That's a big piece of this, right?
Enormously so, yes.
Yeah, you got to somehow document it. I haven't seen how they're going to do this yet, but somehow you have to explain to them, and then you have to explain to the seller, if you're taking the listing, that if another broker comes in and asks for a commission, you don't have to pay it.
That's correct. And so that takes me to the Northwest MLS, and they have already in one of the articles that I found, they created a new document that specifically speaks to how buyer compensation is being paid. And it says that they must, how do they put it? The seller doesn't have to pay the buyer agent anything. And there's 4 paragraphs of content in their contract that basically says I think in both this one and the other one, that the money to the buyer agent comes directly from the seller, no longer flowing through the listing brokerage.
Well, it didn't make, what it did is it didn't eliminate the broker compensation. It says you have to make it, it has to be voluntary.
Correct.
So, right. So you can still have, now here, the deal with Northwest MLS, there was no case against them based on the Sitzer-Muller cases.
Yes.
The case against NAR.
Right.
Through the DOJ, it's a preemptive strike.
Correct. Absolutely.
Right.
And you and I both know the CEO of that MLS. He's a very smart guy.
Yeah, Tom
Ertelbrink. We worked together when I was serving at CAR back in the year. And without question, it was a preemptive strike. It was, I don't like all this stuff that's going on. We might not be named, but at the same time, this could be really bad. And rather than doing nothing and being the doee, let's do something. And that's when they took action. And but let's go back to MLS.
So here, first they made the offer of compensation voluntary. MLS's NAR MLSs can't do that.
That's correct.
Right, because they're bound by the rules, right? So Northwest MLS could do this. MLS PIN can do this. They can make the offer of compensation voluntary, and that's what they did in October of last year.
Right.
October 22nd, I think. Northwest MLS did this now to make sure that, how do you guarantee compensation for people who represent buyers? You have to create a structure somehow in the document, and that's what you're getting to. They created this documentation to kind of help buyers somehow, buyer agents somehow maintain a consistency in compensation.
Yeah, but it's interesting because the article says the addendum specifies that the seller may offer no compensation to the buyer. A brokerage firm may offer some, may offer something else, may credit. It's fascinating. And MLS PIN similarly it's very similar to me, the two of them, and what they chose to do.
Well, so now remember, the MLS PIN didn't choose so much as they settled.
That they settled and agreed to. Yes,
right? MLS, the Northwest MLS did this on their own.
Right.
And again, the big thing is the offer of an offer of compensation from the seller to the buyer broker is voluntary. They didn't eliminate. It's not been eliminated. But now, it could get eliminated in these other cases, and it could get eliminated. But right now, in these 2 big private MLSs, it's no longer a mandatory
requirement. And of course, so much could have been different had there been buyer representation agreements going back in history. And so I'm going to go back to education. So my big concern, and why are we doing this, is because if I can't get in front of everybody that should be hearing, at least maybe I can get this video in front of people and have them hear. But the point is that our brokerages, our agent population, and I'm generalizing because I do that a lot, I'm way up at 40,000 feet, if are not helping the agents that are out there in the way to get them to get a buyer broker, buyer representation agreement signed, whatever that looks like. But we also have to understand there are some states, and I'm not talking about these states, like if you look at Florida, Florida is a transaction brokerage state. There are certain states that there are laws that they don't have, officially don't have agency per se, but they still have some kind of compensation issue going on, and what's going to happen and how is it going to change and how are they going to deal with it? Because it's a thing. But within that, even within that, because even looking at the Northwest document, if there's offer compensation, then the credit to the buyer can be done within a buyer under a buyer representation agreement, and the credit will come still through the seller, but to the buyer brokerage. But if there is none, if the seller denies, then the buyer is going to have to pay the buyer's agent, and there's all kinds of additional questions about that, and how is that going to happen? They don't have a lot of money, especially first time home buyers, et cetera, et cetera, et cetera. All of that is valid. But the point is that there is not enough good education on what to do here. And of course, the code has changed. You knew this. The Code of Ethics has added more content. And in two of the things that are spoken to specifically is one of the most important is that you can no longer say to a seller, or to a buyer, don't worry about it. And this has been said in a lot of areas, but don't worry, buyer, you don't have to worry about paying me the compensation. Working for you is free because I'm getting paid by the seller. That can't happen in the end. And I'm not sure there are enough brokerages that are telling their agents that. And the other thing that I personally have seen, Saul, which has given me some of these gray hairs, I name them. See those? They have names.
Yeah, I bet.
Some of what I have seen on some of these forums on social, like I remember one, I just about had a cow and I just walked away. I knew if I'd gotten into it, it would have become a battle, where this person says, I can't believe on Facebook and social media says, I'm not showing those listing. That agent's only offering $100. Why would I show? That's a violation of the Code of Ethics. So they've changed certain things that say specifically, you cannot search by compensation being offered, which will go away in some cases, like in these cases. You can't tell, and you cannot choose to not show a property because you're not getting paid enough. You can give the choice to your buyer and say, listen, buyer, we have an agreement here that I'm going to get whatever it is, and this house is not offering that. How do you feel about it? Do you want to still see that house? You have to have a conversation more than ever before. Remember the day when you ran out the door and met a buyer at a house that you didn't know, in an empty house? You have to have a buyer counseling session. You need to take the same amount of time sitting down with a buyer talking about all of this as you would be sitting down talking to the seller about listing their home. Sorry, I'm a little whiny. I get a little passionate here.
I get it. So we're talking about this again. At the crux of it's very simple. Is that there's these models to allow for people to get compensated for what they do in a real estate transaction. Correct. That's it. It started as sub-agency. It progressed to offers of compensation. And now we're at a point where it's a paradigm shift. We're going to have to figure out another way. So we can create a lot of scenarios. I'll create one. Let's say the seller says, okay, now that you've told me and I've signed this document that says I don't have to pay the commission, I'll pay 1%. Right. Now, the agent representing the buyer, if they believe they're worth 3%, if that's their model.
I just want to be careful on antitrust here.
No, I get it. But if they believe that their model is they're worth 3%, then to ensure consistency in the compensation, they got to get a contract from the buyer that says, basically, I'm going to attempt to get my commission dollars from the seller. Right. In the event I don't get our agreed upon compensation from the seller, you become responsible to pay me the difference. Correct. And that should be in the contract. And that's what people are afraid of. They don't want to have to prove that they're worth something. Right.
Well, you're preaching it to the choir right here. How many years have I been speaking about value proposition? I even did a micro class for REBI on value prop, and I think I did one for NAR as well. That if we have never been very good at explaining our value. We've never done a good job of explaining, here's what I'm going to do for you. And we as an industry, for the most part, have totally failed in that area. And I one of the things I love joking about is, especially as an SRES and working with a lot of seniors. And when I'm teaching a class, especially that class, I would say, okay, but let's talk about you competing against me personally to try to get a listing. We're both going for the same listing, and you now are competing with me. How are you going to do that? How do you present yourself in a way that makes you better? And it's not about money. Can't be about money. You can never use that as your way. It's got to be about what is your value compared to mine. And if you know how to do that well, good for you, because then you're going to be fine. But if you don't know how to explain that, if you don't know how to give an elevator speech, if you're not confident in saying this is what I do, it's tragic. It's really upsetting.
You know, the way I always explain that, Jenny, it's always said to realtors, here's what you have to see. You have to be ready for this. Why would you hire you
right
to sell your real estate?
Right.
What would you say to you to
right.
convince you to hire you to sell your real estate? Because that is your pitch.
That's right. That's right. That's right.
So in this, so what we've got in the MLS world now is we've got, and it all, again, it revolves around compensation. It always has. How do we bring competitors together to cooperate with one another for the good of the consumer, where you get paid for the job that you do?
Right.
The models have evolved over the years, and it's evolving again. That there are different rules for those MLSs that are taking advantage of the Arizona Mission Insurance provided by the National Association of Realtors, association-owned MLSs, of which there are two types, committee or wholly owned subsidiary, and the broker-owned MLSs that don't have to comply with those rules, and then the litigation in the industry that's forcing change.
Yeah. Isn't it fun?
I love it.
Yeah, well, you and I both are data-driven human beings. We are both people who pay attention, and at some level, I understand that it may be best for a buyer's agent to be paid by a buyer, and vice versa. But then there's this whole another component, which is going to be just a fragment of time, and that's very simply that what lenders will and will not do. Look at the VA. In a VA situation, the lender, the buyer cannot pay the buyer's agent's commission. And me, Saul, it always comes. Why am I doing video? I'm interviewing so many more people. I'm having so much fun doing it because I love these conversations. And if they can help somebody else, but I feel more than ever before, we as an industry are failing I shouldn't say that. We as an industry are not doing as much as we should be doing to educate the agent that's out there in the field on the right way to do things.
Well, I agree with you, although I think a lot of it too could be on the agent side, because
no question.
We got to look at the agent side.
I'm too busy. I don't want to show up.
Right. Now I'm going to go back to this one thing, because one of the things that people complain about, or they say this could never happen, it's that finance piece, right? Now, and what I say is I'm very confident that should the laws change,
I agree,
the world of finance is going to figure out ways to make this work, especially the federal government. Remember that home ownership is a critical part of this country. And we've got a housing finance system that is established to give everybody that it can the opportunity to buy homes. And just because the compensation structure changes on the real estate side does not mean that the lending side is not going to adapt once it sees
totally agree
what it has to adapt to.
Totally agree. But again, the way the little boxes, and we have the boxes all in a row, and there's got to be the dominoes, call it the domino. So the first domino has to fall. And then everybody's, like you just said, there will have to be changes. And this is what I say to people when I'm teaching and I speak about this. I say, everything's going to have to change. This happens, then there's that change. That's going to trigger these changes. And all of the changes together are going to fundamentally be that paradigm shift you're talking about. But it doesn't mean the real estate world is ending. No. It just means we're changing. And it's not the first time we've changed.
No, we change all the time. And you know who's going to be in the forefront of lobbying to make these changes, to make it continue to work? The National Association of Realtors.
Yeah.
People ask me, oh, the NAR didn't do anything for me. Oh, they're worthless. Oh, I shouldn't have to be a member. It's a bunch of baloney. These people don't know what's going on. They're not really professionals in my mind. If you take a look at what NAR does, you'll realize it. And if you think there's a big change coming, you're right. And who's going to help sort this out and make it work so that people can continue to buy and sell homes? It's going to be the National Association of Realtors.
Well, I agree with you, and that's another place that hurts my heart, because I have seen people say stuff on social. What does NAR do for me? And then I go down my list, and I find people don't even realize how much free data there is on the NAR website. They don't even have a concept of how much they're involved in so many areas in so many ways, and all the things that all the research and the data that it's part of your member benefit. I always come back to education, so you know that. I just wish that the agents would understand the importance of all the education possible. When I teach, I always say, this is what I do. I am a research nerd. I love research, and I can share with you, I study at least 2 hours a week. Something, whatever the case is, it's something I'm studying. If there's something new, I'm going to look at it, because as an educator, I feel I have an obligation to do that. I don't feel I have the right to stand in front of somebody and tell them stuff if I have not read what the stuff is. I have the responsibility to do that. It's just the way I've always been as an educator. It probably goes back to all the years in management. You know, we always change, and it'll be okay. And it's just, everybody has to pay attention. And
Yeah.
when I was asked to do a code review for a state association earlier this year. And when I went through the code and the changes in the code, people didn't know this stuff. And people don't realize that the code changes every year. Every year
Well,
something's done.
so I'm astounded. I participate in a number of like 15 different social media groups. And one of them is a group of people that prepare for the state exam, or for their state's exams. So it's an interesting group. And I'm a teacher, so I love being on there. I can answer real estate questions all day long, right?
Yeah,
From
right.
ownership to encumbrances to math and land
All
to
of the
contracts,
above. Yeah,
right?
yeah.
So, and I like to help people. But I see these posts where people say, I failed the state exam 6 times, wish me luck, I'm going. And I'm thinking, what is wrong where people are failing exam? What is the caliber of person entering the industry? What are the study habits? What have they learned? Can they read? Do they understand the value of real estate, the language of real estate, and learning the definitions and studying the words?
And discipline.
Right?
Let's talk
Well,
about discipline.
well, so I got a call yesterday from an old dear friend of mine. He's a real estate educator. We knew each other in 5th grade in Hawaii when I
Oh
was in
my
6th grade.
gosh.
And so he called me because he says, I want to ask you a question. He says, you think 73 years old is too old for somebody to be teaching real estate? And I said to him, I said, yeah, and then I stopped and I said, it depends on whether or not you like it. Because if you like it, this is beautiful. You can teach real estate forever if you like it. And he said, well, that's the problem. I don't really like it anymore. He says the classes aren't as full. People want to take it online. They're not studying as hard. He said, I just don't get the same satisfaction as an instructor. And so this takes us back to, yeah, we can try to be educators,
Yes.
but if the student's not there,
Yes.
right, what are we really doing?
Right.
And so I think we want to work to make the people that are in the industry as professional as we can. We want to help as many people get into it or want to make this a serious business, knowing that residential real estate is not the only thing that you can do. Real estate's an industry. And I always saw residential real estate as an entry position, that you can branch out and do all kinds of things in the real estate industry. Fundamentally, you got to get that course, you got to get that license, and then you can do a lot of things. And while real estate might not be for you, don't sell yourself short. It might be that residential real estate is not
Could
for
be
you.
something else. Yeah,
And it might be something else in the
Right.
industry. And if you like real estate, stick with it, work with it, and make it a business, right? And so we see that too many people they get too locked in, and there's only one thing, and it's selling houses or selling condos. And there's so much more to this than that.
Well, I've been very blessed to be asked to working with a real estate education company. And I've had the opportunity to write a couple. They first reached out to me through a mutual friend and asked me to write a fair housing in California article, which I did, and they liked it. And then they asked me to write another one. And one of the things that in doing my research for the article, I found somebody somewhere in the country said, yeah, that, you know, real estate working with sellers is easy because you just kind of get there and there's so many offers, it'll be great. And then you just close the deal and you make money. No. And not only that, when the market shifts, they say, I don't want to work with buyers. Well, guess what? Do you want to be, yeah, it's harder to work with buyers in the market we've had where you're one of 15 to 18 offers and you hope that your buyer is the winner and the seller is trying to figure out what one to choose. This is not a casual business. This is not hobbyish. This is work. And it requires you to stay ahead before shifts happen, that you know the shift is coming and you're prepared. You know,
that's why education is important.
Absolutely. I made as much money because I still sell houses. I made as much money during the financial crisis as I have any other year. Nothing. I just shifted the way I did business. Nothing changed for me. But again, I've always treated it like a business and that's another whole thing. I'm doing something for South End Regional on one of my original courses I wrote back in the 90s. And it's all about, you know, treating your business like a business, you know, talking about you're creating your plan and understanding what you need to do and how much managing your time, all that stuff. So yeah, it's interesting times, but we're going to get through it and we're going to be just fine. It's just going to be different. And it's interesting to watch. And I love our conversations. We probably should do this once a month or maybe once every other month before we drive each other nuts, because there's
always, you let me know. There's always something to talk about.
Always something to talk about. Any final thoughts, Saul, before I end?
Well, I just think that the most important thing, I think, is to pay attention to these changes. They are going to change things. And then look at your real estate business as a business. Market yourself, market your services, market your listings. Market yourself, market your services, market your listings. Right?
Yeah. Yeah.
And pay attention to what's going on and contribute to RPAC. I'm big in private property.
We had a video on RPAC. Yep. I remember that. Yeah, absolutely. Well, my friend, it's always a joy. I love chatting with you. I get to see you more on video now that I get to see you in person, but I'll probably be seeing you in Anaheim in November. So just have a great day. And I really appreciate your time as always, my friend.
Great to see you as always.
Take care, honey. Well, I hope you learned a little bit. I hope you gained a little bit more knowledge. As always, my information and Saul's information will be at the end of the video. You're always welcome to reach out to us with any questions. We're always available if you have any detail you want to go through. But most importantly, I think the goal for both Saul and myself is to make sure you're paying attention to what is changing. And as I said at the end of the video, change doesn't mean the end of the world. Change just means change. And this one could be a big one, but it doesn't mean the world of real estate is ending, because I don't believe it is. Neither does Saul. So I hope you enjoyed. Please reach out if you have any more questions, and I'll see you the next time. Don't forget to sign up because I've got more stuff on the horizon. So sign up. See you soon.